because I'm going to tell you I'm a bit livid. Just a bit.
Can you take that up with her?
Well, I interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, if Ms. Tope were representing you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. I'm going to set an order to show cause for Donna Tope to show cause why she should not be held in contempt for the filing of this on this case.
Your Honor, we're here for our 7th hearing in this matter. If you recall,
And you might be to 10 by the time you guys get done, but go ahead.
But at the last hearing, we had our motion. It was a motion hearing.
Yes.
And you stopped it, and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Donna Tope with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on her behalf.
You received what?
I received an email from Donna Tope with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on her behalf.
That was on Friday you received it?
I received that on Friday afternoon. And Ms. Tope,
No, I got there.
I may be able to correct that.
Hold on 1 second.
Your Honor, I also have the email from Ms. Tope, which it appears like she's still representing the defense.
I don't.
Oh, there it is.
January 14th. They just threw it in the plan. All right. Okay. I did not get a judge's copy of it, but I'm just. So. Hey, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Tope. It's blamed on a computer glitch from the previous affidavit that she filed in response to landlord's MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice. And it does not appear that they asked you for leave to file this corrected response to our MSD. Tope filed this on behalf of the wards, even though she was required to withdraw from this case, and she did withdraw from this case. Tope's filing in her email, which again, I have the email, which demanded a copy of landlord's MSD. So it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Tope's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service falsely states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th. And again, I didn't receive a copy of this filing until Friday afternoon, right before MLK holiday. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument, that they could be subject to sanctions. They made the argument, and they continue making the argument.
I had to deal procedurally, I guess, before I get to the substance of it.
I could address this.
So, well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address that?
Yeah, please.
I had no idea as to procedurally. All I did when we left is said, your affidavit was like glitched, incorrect, you've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, hey, just so you know, I fixed my affidavit. And that's as a witness, not as a lawyer. So what she says in her affidavit as a witness, I didn't have anything to do with it. And I didn't even realize it would be an issue. I told her that her affidavit was not correct at all. And that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. He's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on, saying, can you show, were they CC'd on that, do you know? Or
Yeah.
can you show them, and then I want to see the email. Those time machines.
I don't think it's refiling. I just think it's a refiling of the original one with the correct affidavit. So I don't agree with the physics of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, the correction to what we filed.
Mr. and Mrs. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Tope and said, this is all wrong, here's the corrected affidavit, and you guys sign off and you file it. That's one thing. This is a whole other thing along when you take it in the context of that email. I don't know why she's still communicating with counsel. It doesn't make any sense to me.
did not ask her to do that at all. And I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Yes. Believe me, I'm
Have you,
staying as far away from as possible.
did you read the affidavit?
The initial one,
No, I understand the initial one. Did you read this doc?
no, actually, I didn't. I did not.
I did not know.
Updated, I mean, because I didn't even realize that usually when we submitted it, that we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that procedurally, if Miss Tope came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this. Here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed. You guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had knowledge that she did what?
That she fixed it after the fact, but she never told me that she was.
What does that mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So when was that?
At some point after they received it.
Well, he just got it.
We received it Friday afternoon. Even though it's stated on there January 8th.
Yeah, I would have to look. I don't know.
You have to look at what?
My email.
Look at your email. I want to know. You need 14 days for an article of the house.
So. Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
What?
This helps you understand my brain frazzle. I also had a case of strangles at the farm.
Okay.
Your Honor, I would add in the context that Ms. Tope is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, counsel kind of let me know where his client, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how I.
It's 14. It's 14 exactly.
Yes.
Was there anything recently filed in the circuit court action, counsel?
No, Your Honor. Yes, our witness list. Yes.
Right. Okay. But I mean, anything else by Ms. Tope that was.
I filed my witness list and then she filed her witness list hours after.
After. Right.
I can find that date. But to my knowledge, Ms. Tope is still representing the wards in circuit court action. And it seems like they are still having communication in this case.
Yeah. And the communication I don't necessarily have a problem with. What I have because I don't know that I could stop that in anybody. But what I do have a problem with, so things are filed before this court, presumably on your behalf, but without your knowledge. That just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point.
No, we just don't have lessons.
I don't think either one of them said they've seen it before today. Did you see it, ma'am?
We talked about it. That he was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you seen what was filed in court on your behalf?
No.
Do you know where Miss Tope is right now? Because I'm going to tell you, I'm a bit livid, just a bit.
Can you take that up with her?
Well, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just this court's view. But I also have these motions before me that I need to rule on. But at each, and so we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is tenfold that. Because in effect, let's look at it this way. If Ms. Toper represented you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf, and you have no idea what it is.
I understand. I should have taken her affidavit and had.
When multiple people share control over a decision, each person assumes someone else handled the risk correctly. Legally, though, courts do not operate on assumptions. The moment filings are submitted in your name, accountability attaches whether you reviewed them carefully or not. That gap between trust and verification is exactly what starts creating sanction exposure here.
Aaron, submit it. That's a correction.
I'm not going to tell you what you should do because I mean, I haven't looked closely at what she submitted vis-a-vis the other part, but you can't respond to her affidavit.
As a witness, I thought, because she was a witness to the
No, but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea, but no, specifically, no.
You don't know what it says. The only general idea you may have is what Ms. Tope in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
Okay.
No, I mean, that was a question.
Oh, I cannot give you the specifics of the substance of what was filed other than it was the affidavit. And I know in general, as a boarder, what happened with her horse and the injuries sustained due to the fencing. And the witness that she is to the collapsing buildings and the fallen trees and the heavy equipment.
But this is wasting the court's time, and it's wasting plaintiff's time.
I don't need it.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit unclear. Counsel receives this on Friday. That requires him to do certain things, increasing the cost to his client. he comes here and then has to spend time in this courtroom making an argument regarding something that you don't know anything about, but are connected enough to the person that filed something on your behalf. That's a problem.
Your Honor, I would just also add, this has been a habit. We've had hearings set and tenants file motions and send them to me 2 days before the hearing. This is a habit.
No, I get it. I get that part of it. And most of that stuff we can sort through, but when that was happening,
I think we got the motion for summary judgment the day we were coming in here. No?
well, you may have gotten it, but I think somebody.
Yeah, I had to file. It wasn't noticed for the same day.
I'm gonna let you go ahead and argue your motion. All right, go ahead.
Your Honor, would you like me to address the affidavit?
Yeah, I knew we were gonna get there. Yeah, I'm gonna let you do your motion. It's a fair question as to whether or not.
Your Honor,
Hang on a second. The court's going to stand in brief recess.
authorized.
Back in the case of fixed housing, 401k plan versus the wards. Here's what I'm going to do, much to your dismay, because I'm going to give you an 8th date. Okay. An 8th date to come back, an 8th time. But I am adjourning the motions for summary disposition. I am also, after some consultation as to some of the ethics that have been involved, which is why I was taking the rather prolonged break, that I'm going to set an order to show cause for Donna Tote to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge of any of that. And so I'm holding to that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you, an appropriate billing from you, laying out from certainly the time Friday, time that you received this, what you had to put in to do that, and your work up to that, as well as what other stuff you may have to deal with this being adjourned out 2 weeks to that day. I will then adjourn it for the motions and for the order to show cause to February 3rd at, you wanted me at 2
p.m.
At 2 p.m.
Can I hear again what those two purposes are?
One of the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Tope should not be held in contempt of court and or sanctioned.
On that second note, how does that have anything to do with me? And
Oh, it certainly does, because here's going to be part of your problem, as it may be, and that is I will have to make a determination if Ms. Tope gets here and says that that was filed with your full knowledge and authority because you have represented to the contrary. And so I would suspect that when the two of you get here, you're going to be very much at odds.
So you're gonna reach out to her, so I don't have,
Oh, no, yeah, we will be sending a little piece of paper commanding her to be here.
but has. Wait. Okay, can I ask one question before you adjourn today?
Yes, ma'am.
Plaintiff's lawyer mentioned that I had reached out with 2 additional complaints. And I just need to understand what my legal process moving forward would be when I have a fence fall over or don't have water, because those weren't additional complaints from the past. Like,
You
I'm
can,
still
you
there.
can certainly reach out
I'm
with
just letting you know.
whatever, right, you can reach out with whatever repairs. I certainly would have been in a position to kind of address that today, but I
realize that my landlord is probably not, as usual, going to do anything about it, but I want it documented that, hey, on this day, the wind blew this section of fencing over. It just keeps happening. So that's okay to email him.
you can email him
Okay.
as long as it's you emailing him.
Yeah, it's no motions or anything. Thank you, Your Honor.
Sir, was there anything else?
I would just say when you email me, put that it's for this action because Donna Toke is still representing you in a circuit court action. So be clear what you're talking about. Because there are 2 actions.
So regarding my lease, these things are falling over. Is that
I
correct?
think what he's trying to say is that you are directing your concern regarding this case
Right.
as opposed to the case that you are represented by Ms. Topon.
No,
Because presumably,
So,
so listen to what I'm saying. That it's regarding this case because presumably if the complaint were to be in that other case, he would be receiving a communication from Ms. Tope.
okay.
I'm trying to
And yeah, right. Because he can't respond to you in a case in which you are represented by an attorney. So you have to make it clear that this is the case you're dealing with.
Okay.
All right, folks. Thank you.
Thank you.
And so that, I guess one other thing, I was not aware of that filing because it had gotten put into the file and there was no judge's copy that was presented to the court. So it did not come to me.
Maybe that order.
Oh, that's right. You got to do that. What's this?
This is, yeah, there.
Thank you.
Thank you.
What makes this hearing significant is that the conflict stops being about the original property dispute and becomes about process integrity itself. Courts can tolerate disagreement. They can tolerate aggressive litigation. What they struggle to tolerate is uncertainty over who authorized a filing, who reviewed it, and who is actually accountable for its contents. The judge repeatedly returns to one concern: resources were consumed responding to documents that even the parties connected to them could not fully explain. That creates a chain reaction. Opposing counsel spends additional time preparing responses. Hearings become longer. Settlement opportunities begin collapsing under procedural confusion. And eventually, the court starts examining whether the legal system itself is being misused. There is also a deeper strategic problem underneath this exchange. The defendants appear to believe the issue can be separated into technical misunderstandings: an affidavit correction, an email, a filing error, a communication issue. But the court is evaluating pattern and credibility, not isolated mistakes. Once a judge begins questioning whether filings are being submitted without clear authorization, every later explanation gets filtered through that concern. That is why the hearing escalates into a possible contempt proceeding. Not because of one document alone, but because repeated procedural uncertainty slowly erodes judicial trust. And once trust becomes the issue, even routine litigation decisions start carrying much heavier consequences. Sometimes cases turn on evidence. Sometimes they turn on credibility. This hearing shows how quickly one can become the other.